something that's definitely unique with this administration right now is the business removal crossover, right?
Yes.
Previously, if you had a business case denied, it was denied, USCIS left it alone, you could refile, for a tongue, figure something out. Now, immediate denial, NTA, you're in proceedings. So many employers have no idea how to support their employee when they're put into proceedings if they want to.
The NTA memo, or notice to appear memo, this is not to scare the community nor in any way discourage filing things, because that's what we have to do. But there is a new policy by the administration that anything is denied. Does not matter if it's humanitarian, if it's business, you are automatically referred to court.
Yeah.
And so that's why Megan and I have to come in with these creative arguments, because, people who are the best business immigration practitioners probably have not had to deal with the removal space. Why? Because the clients are resourced. Perhaps they could return home. So to continue with the concept of motions to terminate, that's also where I've actually had some success, but I know practitioners are very scared to challenge. Historically, if you saw a case might have relief in the future, you might plead to your notice to appear, right? You'd go into court, you'd say, yes, I admit these factual allegations, I concede the charge of removability, however, I have this other remedy. Now you cannot rely on that being a strategy. So you need to review your notice to appear and any other documents generated by the government and see if there are defects and flags, so that before you even get to the point that court is commencing, you're explaining, this is an error. My client was admitted in status, be it employment or otherwise. They cannot be removed on this basis. We need to terminate now before we're even litigating the case. So I've had a motion to terminate that was successful recently for an unaccompanied minor, where when I was reviewing the documents, what I noticed was that this child, there were no notes that they had been interviewed in language. There were no notes that by ICE that they had been interviewed with a parent present, and they were 12 at this time. So any admissions as to them being from another country, by our special protections of children, our special regulations, there are enhanced protections about translation, about having adult present. Obviously, this makes sense, right? You're 12. So I was able to educate the court, point holes in all of these documents and show you have to terminate because the government cannot hold their burden that this individual is removable. They cannot do that because their evidence is tainted. Also, in the removal space, if you were caught up in a raid, they did not know your identity in advance. They just saw you're not from this country, in their opinion. Where was your evidence? Were they just the teacher walking down the street, or did you just take them? And so can you actually remove them? They might not be able to prove that, and I've been quite successful holding them accountable. Sorry, you went into a workplace, you took everyone there. Did you know it was Megan in advance? No, so you cannot remove her. Or perhaps we can suppress the evidence. So I've also done a lot of work with suppression, trying to get rid of the underlying evidence that would even allow the government to proceed with a removal case. So I have worked with some of the raids cases where people have been taken from warehouses or car washes and demonstrated to the court that these were not legally justified apprehensions. And sometimes our immigration court listens, and if not, Megan and I have discussed with you in the past federal litigation, there are district court judges who will listen to those arguments because our Constitution is still valuable. This country is built on laws for a reason, and we can educate them as to those reasons.
You have so many cases, and they're under so much pressure right now to justify approving anything or terminating anything. And we had a case with your office that was VAWA case. They had their prima facie determination renewed multiple times. The day we went to court, every other termination request was denied, but because I knew that this judge really valued judicial economy and wanting to make sure that we're doing things as efficiently as possible, I brought up that one of the derivative children was aged out and would have to present his own new application, which would create more work in court for the judge. He said, okay, motion to terminate granted. This is most efficient for everyone. So much of it is knowing who you're dealing with and how to make the arguments to them.
I had this judge in another case. Actually, I believe you and I previously had collaborated on Joseph, where it was an individual family petition. Child had petitioned mother for whatever reason based on a mistake. The case had been denied at the green card stage. We get to the court, it's clean. The judge can grant adjustment of status. The same judge, he sees The I-130 is approved. The evidence has been ready. The attorney has prepared the evidence. Let's get this done and give a green card in court today. Great. Just make their job easy. Do your homework.
Yes, think outside the box. Don't be stuck, because this is the new normal.
Yes.
But with the new normals, create new pathways.
We cannot shy away from the fact that a lot of bad things are happening to our communities. And so I did have a client I was helping another office with. She went to try to go to her fingerprint appointments. This is standard in all of our cases. She goes to her fingerprints and ICE apprehends her outside of the fingerprint appointment. She did not even make it into the appointment, right? And so now she's in detention. Mother of a disabled child, U.S. citizen husband, literally just an amazing person. In fact, that's actually what happened in my case ultimately, is the judge said, actually, DHS, I don't think you have evidence that she's a bad person. All of the evidence counsel has presented is that she's a great person. So I went to court. I said to the judge, I don't know why we're here, Judge. In a traditional situation, this woman would have had her biometrics. She would have proceeded to her I-130. She would have done this in one step outside of court. And he said to me, well, unfortunately, counsel, in this universe, that she is a visa overstay, so they were entitled to detain her. I said, great. Well, here's the thing, is she has an I-130 pending. If that I-130 is not approved, Your Honor, you cannot approve her green card here. We are stuck. And so I was able to convince opposing counsel to expedite the I-130 interview. We did that detained. We were able to get the I-130 expedited and approved before her next removal hearing. I go to the removal hearing, she's still detained, and I tell one of our very most not nicest judges, a very difficult guy, I say to him, if she's released, she has approved I-130 now. She can go get her green card at the field office. Why are we keeping her in detention? She's away from her kids. Her child. And he said, well, I can grant the adjustment in court, so why not keep her detained? We'll deal with that here. We can do that. Why should I let her out? And I said, well, it's not about why, Your Honor. It's about the fact that you do have discretion still. Nothing in the memos or policies have divested you from your own discretion. And he said, well, absolutely, I'm independent. I don't have to deal with, of course I can make my own decisions. That the concept of him being forced into a decision upset him. And so he said, DHS, what is your position? Why do you think she needs to stay here in detention? With the horrific conditions, with the no medical care, with the no food, away from her child. And they basically said, because we can't. And he said, well, I'm going to use my discretion. I'm going to let her out. And actually, just last Friday, one of our colleagues who's here went with the client to the interview, and it was easily approved. The officer said, I saw the file from the I-130. I see what happened in the immigration court. Green card, done.
High five.
Yes.
Dude, wow. That is great.
We are in the long game right now,
Yeah.
right?
Absolutely.
It seems like you're never going to get there,
Yes.
but you have to keep going, and you will get there. I had a case inauguration week, right? He's traveled on advanced parole for his pending adjustment multiple times, like 13, 15 times, no issue. Tries to come back the week of the inauguration, accuse him of student visa fraud, and deny him entry, revoke his advanced parole. Put together a whole packet of documentation showing no, he was a bona fide international student, he went to all of his classes, he did what he was supposed to be doing, tried sending it to the port, tried sending it to, ARO. No one looked at it, so we go and file federal court litigation to challenge the fraud misrep finding. This is now like a year into it, right? Finally get into negotiations with the U.S. Attorney's Office. I give them the packet. They go to CBP agency counsel and say, here's all this evidence. This guy doesn't look like he committed student visa fraud. So they say, okay, we're going to get rid of the fraud misrep finding. He's been stuck in Canada this whole time. But they took his EADAP, so how's he going to get back in? So part of our settlement discussions were, okay, you're going to remove this fraud misrep finding, but also you're going to facilitate re-entry to the United States. Here's the dates, here's the flight itinerary, here's what you're going to do. This was done months in advance. Get to day he's actually re-entering. He shows up to the airport hours in advance because we planned accordingly.
Because this was allegedly the plan.
Gets to check in, and they're like, we have no record of your case. We don't know what you're talking about. You can't come. You'll have to come back another day. I call the U.S. Attorney's Office. She's not in the office. I am so persistent that they eventually give me her cell phone number. I get her on her cell phone, explain what's happening. She's like, oh my gosh, no, I see that I gave this to agency counsel. They said it would be sufficient.
Right.
Let me talk to them. Spent all day going back and forth, but they give them the appropriate waiver documentation, and now he's back in the U.S.
As an advanced
with his
parole.
adjustment pending.
Yeah.
There are so many different agencies wearing so many different hats, and you would think, oh, it's immigration, they communicate. No, they don't communicate with each other. They have different systems, they have different people, they have different supervisors. So a good attorney will think, how can we make sure they are talking?
Mm-hmm.
You know, my story, Megan's story, we've listed almost all of the agencies, right? CBP, U.S. Attorney, we've got them all going on at the same time. Understand that that is how you get success.